Stepping in as a trustee or personal representative for a loved one who has a business or complicated assets such as stocks acquired in a private placement can be intimidating and overwhelming. And for good reason. As a trustee or personal representative, you'll be held to a high standard as you administer the trust. And here's what's interesting. It's actually a standard higher than the original owner was held to. If you have specific knowledge, such as having owned a business before or being an attorney or CPA, you're held to even a higher standard. And here are 3 steps you can take as trustee or personal representative that will help you better manage your responsibility as well as reduce your liability as you administer an estate or trust that has business or complex investments. Step number 1, assemble a team. Even if you have experience with owning and operating a business or in managing an investment portfolio, you can be held accountable for making decisions that have a negative impact on the viability of the trust's business or assets. So seek help from a qualified professional such as a CPA or probate attorney with experience working with businesses or other relevant advisors. Step number 2, delegate control. Now you need to find a qualified person to take responsibility and accountability for his or her actions in managing this business and operating it. That person must be committed to making the right decisions and even difficult ones such as firing family members. Imagine that. That's one that the previous owner probably didn't want to even face. This in particular is a common and difficult decision that must be made with a number of trusts. Step number 3, maintain communication. As personal representative or trustee, it's your responsibility to keep beneficiaries informed of the state of the business or other assets. Passing along the commitments and responsibilities of a business and business assets through a trust can be complicated. The trustee or personal representative who administers the estate should understand the responsibilities of the position. Without information, knowledge, and expertise needed to run a business profitably, the trustee can be held liable for a decline in the business. Assembling a team and delegating control are 2 critical steps a trustee should make to maintain and manage the assets. Make sure to keep the beneficiaries informed and in the loop regarding the state of affairs. Do you have any questions about trust and probate assets, especially if there's a business or complicated investment involved? We'd love to help. Give us a call here at Magellan Law. Our phone number is 602-443-4888.
Hi, I'm Reed Bloodworth, founding partner of Bloodworth Law. Today I'm going to take a moment to discuss trust litigation. Well, first issue we should address is, what is a trust? A trust is a legal creation whose purpose is to hold assets for beneficiaries. A trust is controlled by a trustee. There are many types of trusts. Some of the more common types are revocable trust, irrevocable trust. A revocable trust means that the grantor, the person who is putting the assets into the trust, controls the trust and controls those assets for his or her lifetime. An irrevocable trust, the grantor puts items into the trust, but relinquishes control of those assets, and the trustee will manage those assets for however long the trust is designated to last. Trusts are very beneficial in terms of estate planning. Items that are in trusts avoid probate. Probate can be lengthy, it can be expensive, and trusts are a way that lawyers avoid that process for certain assets. Probate litigation arises in a multitude of fashions. Some of the more common types of probate litigation involve beneficiaries who believe they were improperly left out of a trust, or perhaps a trust was amended and certain beneficiaries were left out, some were added, and the disputes arise. So for example, let's say father has 2 children. He had a trust, and the 2 children were the equal beneficiaries of the assets in that trust. However, later in life, father remarries. Father is somewhat weak, perhaps he's sick, or perhaps he suffers from dementia or Alzheimer's. And the stepmother takes father to an attorney, and she has father create an amendment to the trust, removing his biological children as beneficiaries, and adding herself, or adding herself and her children. This is a very common occurrence in terms of trust litigation. In this situation, the biological children may bring an action against the trustee to have it set aside for multiple reasons. It could be lack of capacity, it could be undue influence, it could be tortious interference with a testamentary expectancy. Some other causes of action pertaining to trust litigation in that context may include an accounting, because the beneficiaries or would-be beneficiaries want to know, where did the assets go? And a trustee's duty is to supply accounting to the trustees, or to the beneficiaries, excuse me. So in that scenario, I, my law firm, would represent either the trustees in defending a lawsuit brought by beneficiaries, or could represent the beneficiaries bringing the suit against the trustees. This is just a common scenario for trust litigation. So, at Bloodworth Law, we represent beneficiaries and trustees. We represent them both as plaintiffs and defendants. Again, my name is Reed Bloodworth, the founding partner, Bloodworth Law. Give me a call. Let's talk about what happened to you.
Hi, my name is Bridget McKay. I'm an attorney in Petaluma, California, and I practice in the area of estate planning and elder law. And today I want to talk about a question I had from a client who has just become the trustee for her parents. Her father passed away, as did her mother, and now all the assets are there and she's the person in charge. This is a big job, and not all the information about this big job is going to be in this video blog, so I'm going to address something very specific. And that is the question of opening and closing bank accounts that are in the trust's name. So generally speaking, when you are a trustee and both people or the single person has died and you have taken over, your job is to transfer assets into your name now as the trustee of that trust. So, Jane Smith as the trustee of the Smith Trust. And so your job is to go to each bank, investment house, wherever cash money or savings or CDs are invested, and give them paperwork you would get from your qualified estate planning attorney that says, these folks are dead, this person is the successor trustee, and they are now acting. So it's very important to get everything transferred over into the name of the trust, because that's the only way you can manage those monies, pay bills, give out distributions according to the trust, and all of those responsibilities that you now have as a trustee. So whenever I get the question, do I need to transfer bank accounts over? I always answer yes. The follow-up is to that, what if I just clean it out and open up another account? Well, that's essentially the same thing. Your attorney, when you work with them, will develop the paperwork you need, get a tax ID number, a new Social Security or tax ID number for that account, so that any taxes related to it will stay within the trust. So any questions like these, you always should contact a qualified estate planning attorney in your area to get follow-up on it. Thanks.